Judgment in the appeal, AIB Group and Mark Redler Solicitors.
Lord Tilson will explain the judgment of the court.
This is a dispute between a bank and a firm of solicitors arising out of a loan transaction in which the solicitors were instructed to act for the bank and the borrowers. The amount of the loan was £3.3 million. It was to be secured by a first legal charge over the borrower's home, which was valued at £4.25 million, and it was a condition of the loan that any pre-existing charge was to be redeemed on or before completion of the loan. The appellant bank paid the £3 million to the solicitors to hold the money on trust for the purpose of completing the transaction. There was at the time a charge over the property in favour of Barclays Bank to secure the amount owed to it by the borrowers under two accounts, totalling £1.5 million in round figures. Unfortunately, the solicitors made a careless mistake. They paid over to Barclays the amount which they wrongly believed was needed to discharge the Barclays charge, but the figure which they paid related to the amount owed on the larger of the two Barclays accounts and not the smaller. £300,000 was owed on the smaller account, but instead of paying that £300,000 to Barclays, the solicitors paid it to the borrowers together with the rest of the amount of the loan. So the Barclays charge remained in force as security for the £300,000 still owed to it. When the solicitors learned of their mistake, they were slow in reporting it to the appellant bank, but eventually they revealed it. The appellant bank then came to an arrangement with Barclays under which the new charge was registered as a second charge on the property. The borrowers later defaulted, and there was a forced sale of the property by Barclays for £1.2 million, from which the appellant bank received a little under £900,000. The appellant bank's total loss on the transaction was around £2.5 million. The question of law is whether it is entitled to recover the whole of that £2.5 million from the solicitors, or whether the amount for which the solicitors are liable is limited to £300,000, representing the amount by which the value of the security obtained by the bank was less than it would have been if the solicitors had done their job properly. The bank based its claim on the solicitor's negligence, breach of contract, and breach of trust. There's no doubt that the proper measure of damages for the solicitor's negligence or breach of contract is £300,000, because that's the amount by which its position was worse than it would have been if the solicitors hadn't been negligent and had carried out their contract properly. But the bank claims that it's entitled to different and greater relief for breach of trust. The law of equity, says the bank, requires the solicitors to reinstate the trust by paying back the full amount which it paid out, i.e. £3.3 million, less the amount which the bank recovered from the sale of the property. The trial judge rejected that argument and held that the remedy for breach of trust came to the same amount as the remedy for breach of contract and negligence. His judgment was upheld by the Court of Appeal, and this court unanimously agrees with the Court of Appeal for reasons set out in judgments given by Lord Reid and myself, with which the other members of the court agree. Put very shortly and simply, the beneficiary under a trust has a right to have the trust properly administered. What that will mean in any given case depends on the facts. In this case, it would not be realistic or equitable to look at the trust in isolation from the commercial transaction of which it was part. If the solicitor trustees had done their duty properly, they would have paid £300,000 more to Barclays, and the bank would have obtained a first charge over the property instead of a security ranking behind the Barclays charge. The bank is entitled to be put in the same position as if that had been done, and that requires the solicitors to pay to the bank the sum ordered by the trial judge. For those reasons, this appeal is dismissed.